Hello, everyone, and welcome to our podcast, What the is Regulation, where we explore different facets of alternative dispute resolution with guests from all over the world. Hello, everyone, and welcome to another episode of What is Regulation by Multi-Level Regulation Student Projects. Today, our guest speaker is Mr. Alessandro Mazzi, who is going to discuss mediation as the default method for dispute resolution, a different perspective on conflicts and how we do business. Thank you very much, Alessandro, for having joined us and for having showed your interest in the collaboration. If you can start by introducing yourself, your educational background, why did you decide to study law, and what are you doing right now?
Well, thank you for having me here. I studied law in Italy at Bocconi University. The degree was mostly focused on, especially the last 2 years of those 5 years of a combined bachelor and master's degree, was on public institutions and international commercial law. I specialized in arbitration and applicable law to international commercial disputes. My first experiences were in commercial mediation in especially Southeast Asia, because I worked in a law firm in Australia and Hong Kong and China. So that was the area of work of my first experiences. Then around 5.5 years ago, I moved to the Netherlands and I started my own business doing legal consulting for startups. And basically and recently, around a year ago, I saw the opportunity to move more towards the negotiation of agreements, helping startups in the negotiation process and the relationship building, including also mediation. This is a little bit of a summary of myself. So I worked mostly in the past few years with technology startups and entrepreneurs.
You mentioned the fact that you lived in Southeast Asia, and more specifically in Hong Kong and China, and you also mentioned that you worked in Australia. And now your own company in the Netherlands, how do you see the view there compared to the view in the Netherlands on ADR and mediation?
Yeah, that's an interesting one. It's definitely so. In Hong Kong, for instance, I was there in 2013 and I was working in the Hong Kong International Arbitration Center. We were dealing with disputes, companies from that area, but also Europe and the US, dealing with China, especially China, Hong Kong. And I saw that at that point, arbitration or mediation or ADR for those disputes was the only way to solve them. They were so complex, involving different culture, different background, than the arbitrator, a judge, let's say, without the technical knowledge, was not able to handle, in my opinion, those disputes. So most of the time, the arbitrator or the mediator were technical people, engineers, and ADR was definitely in that environment, which was, I would say, quite niche because it's big international disputes. ADR was seen as the only way to solve the problem, mostly for, I would say, confidentiality that you probably are familiar with as one of the reasons, but also the complexity of the issue couldn't be handled by a normal judge. And also a normal judge would have meant to be probably the jurisdiction would have been China, which is, I would say, an unpredictable sometimes place to handle disputes. So choosing for ADR is just the safest way for having a dispute dealt very well, and also in a relatively short amount of time. Yeah, I hope it answered your question. In Australia was basically the same. So mediation was seen, especially mediation was seen as sort of like a default, a go-to dispute resolution avenue, let's say.
Yes, thank you very much. Thank you very much for the explanation. And it's really interesting to see that China and Hong Kong have already implemented this system of somehow by default ADR. And then you mentioned by default mediation. So what this would actually mean in practice? There is a specific clause in the contract that obliges the party to go through mediation once a problem arises out of their contractual disputes, or is it just on the basis of negotiations between the parties?
It's from my experience. So you're asking, like, does it happen by force of contract, or it's something that happens after a dispute arises? Usually it's harder to get people to convince the parties to go into mediation if there's no clause in there. It really depends. But usually what I do with my clients, and I make them aware of it, is putting a mediation clause in every contract, because this should be, and in this way you make it a default avenue for dispute resolution. Even before an actual formal mediation, just a clause that says, if a dispute arises, the parties commit to a 2 weeks time frame whereby they agree to mutually kind of conversate and dialogue about the dispute itself and try to solve it without any third party involved. If that doesn't work, then mediation starts. And if mediation doesn't work, then it's either arbitration or actually court. It depends a bit of what the clients want. Arbitration usually for small parties is not really an avenue that I would recommend just for cost-wise. Mediation always. This is from my experience, like in the startup field. This is why it's I took on, say, this initiative to kind of bring mediation to the startup and young entrepreneur scene, is because it's not really known. Although here in the Netherlands, it's somehow some judges, from my experience, I saw they kind of invite the parties to go to mediation before they even bring a case to court. So the culture here of mediation in the Netherlands, it's quite advanced, I would say, compared to other countries.
Yeah, I think that it was some years ago when the Netherlands introduced a new initiative that parties should first refer to mediation, even if they go into court. The judge can refer them to mediation, and then if they don't resolve the disputes, they come back to court, which was quite unique in Europe.
Yeah, absolutely. And you have to understand, I had a few talks with some international lawyers. There is a conflict of interest, of course, because you're saying basically parties can go to mediation and resolve a dispute in a matter of a day or two rather than months or years in litigation. So not many lawyers are willing to go that path. We had a discussion, I will share with you a link, maybe also your listeners will be interested in the discussion about the new Singapore Convention and why mediation, yes or no. I had an interview with other lawyers a few months ago on the Legal Mondo platform. I will share it with you. It's very interesting. And one of the lawyers really goes through like this tension between the lawyers wanted to push towards normal litigation or going to mediation. Sometimes they don't choose for mediation, not because of personal interest, but because they believe that in certain cases mediation is not the right path. So they don't advise it to clients from a place of mistrust in mediation, which is a big topic also worth to be discussed in the future as well. Education in mediation, and the fact that sometimes if a law forces the parties into mediation becomes almost like when forced, when it's not out of the will of the parties, it becomes like a step to overtake and then go to litigation anyways, if you understand. So yeah, it's a complex issue, but I believe that especially in pure commercial cases, most of the time, from my experience, involving a neutral third party to help the parties come up with their own solution, it's the best way forward. If the relationship wants to also go on for a long time, some relationships can be broken, and then a judge, it's maybe better suited to adjudicate who owns to whom, but even a mediator can do that. So a mediator is not only about resolving the dispute and putting the parties together, it's also about what is the best way forward, even if the outcome is, the parties going their own ways.
So it seems like a mediator it's a third party, but it's also highly involved in the process. And there are some situations in which obstacles arise in connection to mediation, either because, as you've mentioned, the parties are not really willing to mediate, so they would rather go straight to litigation. And I'm wondering what type of obstacles and challenges have you faced as a mediator, and how did you overcome these situations?
So there are challenges coming from the parties and challenges that somehow, as a legal consultant myself, I might bring in, which is we're biased to be the. I will start from the mediator. Challenge is the solution bias. So like to bring the solution to the table or advise the solution to the parties, which is definitely something that you're trained as a mediator not to do for several reasons. One, it's if the solution is felt by the parties that was brought from someone external from the relationship, it's definitely likely that that solution that was negotiated and agreed by the parties would not be as strong as if it came from the parties themselves. So if the mediator advised it or brought it in, it's never a good solution. And also the mediator is not part of the relationship, so it doesn't know much about it. But there is still this, especially from lawyer mediators, there is still this bias of, I'm here to tell you what to do, right? Which is definitely not the role of the mediator. So like that's quite a challenge, I would say, if you're used to giving advice as your job, to then be a mediator, being just this basically almost a therapist of a relationship. So like you're trying to get out of the parties the best interests, and then understanding each other's perspectives and coming up with a mutual solution. Challenges from the parties, there's usually one that is willing to negotiate and another one that is kind of like set in their position. So to move that person from position to really opening up in their interest, it's sometimes challenging, because you have, imagine one party really willing to open up a conversation. So you're like, okay, I'm going to get a lot out of them, out of this one party, but then you go to the other one, which is like completely closed up, not bringing anything fruitful out. So being able to manage that difference, it's a challenge, especially at the beginning of the mediation. So having what is called like caucus sessions, like where you go one-to-one with the parties and discussing, it's crucial before you bring them together. So you have to move them away from the position that they come in the room with to their interest, and to look at each other's perspectives so they can soft their emotional status or their grievances, and then somehow open up to like, well, you know what, if I come to a solution in the future, it might be also beneficial for me. I'm not giving away anything to the other party. Other challenges is time. We're very practically, like sometimes it's hard to manage the time equally with the parties. Sometimes it's hard to get them to mediate, even if there is a contract that says that they should. Yeah, and I guess being very honest, sometimes like this is again the mediator struggle, is to be really neutral, because you might be biased towards one party instead of the other. So because it's more closely related to how you perceive and believe the dispute should be handled, for instance. So there are the ones who are biased towards the ones that are stronger positioned, or the ones who are more lenient. So, and that's something that a mediator, of course, has to work on personally as a professional. And this is also, what mediation should be. And I think most of mediators now are not really full-time mediators, but they should, if there would be the opportunity that mediation could become actually a full-time kind of position, then mediation itself will benefit a lot from it, because professionals will be very much dedicated into studying better methods to handle disputes. And you have a lot of them now already, like very, very interesting courses on transformative mediation is very, very interesting, and others also methodologies that comes from psychology fields that really help the parties come together.
Yeah, I feel like in the past decade, especially, ADR has become really and a highly relevant way of resolving conflicts, and it's particularly mediation, as it is very non-confrontational approach, and it's also cheaper in comparison to arbitration. And especially because as well, I feel like the new generations are more inclined to study ADR as a formal education in master. And on this note, I'm wondering, what do you think about the restrictive status quo of arbitration and mediation as well? And how is it going to evolve in the next 10 to 20 years? Will ADR, in your view, will ADR be the new system? Will litigation disappear in the next decades?
Well, ADR, I think, first of all, might be okay. So I would distinguish arbitration from mediation. Let's say that if the economic situation gets worse and worse, it might be that for several reasons, courts cannot be civil, commercial, or commercial courts would not be able to handle a huge load of cases, breach of contracts and force majeure kind of things. It might be that in those situations, the courts cannot basically handle the conflict. So the parties, it actually happened with the first lockdowns in Italy, that courts were not able to handle, like it was just on hold, disputes that, were supposed to go on. So mediation became the only solution to bring businesses forward. And if these, partial lockdowns keep happening, for instance, mediation can become something. In the next 10 years, I'm not 100% sure. If arbitration will be a little less expensive, that could, be reached by small, medium-sized companies, I think that would be a good thing, especially with tech startups. We need like an arbitrator that is very technical and knowledge and knows about these very nerdy kind of topics like open source and software licensing, this kind of stuff. I see that movement that you said about the interest that we have about arbitration and international disputes, and let's put mediation in there as well, because of course now there's an interconnected global world. Disputes between different jurisdictions, companies from different jurisdictions is happening more and more. So it's a good movement that students want to go towards ADR because that's the easiest way to handle a dispute. And imagine even like we were talking in Hong Kong in 2013 about the online mediation or online even arbitration kind of things. And at that time, there were some softwares working out. And now I know that with mediation, for sure, online can be handled, but even arbitration with like submission of documents and stuff is actually happening, and that might be the future of ADR. So the why we're going to be moving to ADR is probably because the private sector will be building softwares and ways to resolve disputes online that courts might take a longer time to do. So that's interesting. So it might be that ADR would grow. And if I would have to suggest to young students where to go into, it's definitely an interesting field. And you work on multi-level regulation, right? So this was my interest there as well, like to think there are laws that are international that can be applicable to private parties as well. It's an interesting field. I found the whole national conflict stuff a bit boring, probably at that time. Yeah. So that's why I decided to go full on international and learn about common law. And because studying in Australia, I was studying and working in Australia in 2014, 15. And just knowing that there is such a completely different way of understanding the law and making arguments, it was amazing, really eye-opener. So if anyone has the possibility to study common law, even if from a civil law background, I think it's very powerful, because disputes with the US would be more and more, and then you have to know what kind of mindset they have towards the law, right? And contract law, it's so much different actually we are influenced a lot from common law and the US or the UK and how we draft contracts. So we're starting to draft way longer contracts, or professionals start to use templates that come from the US because of the big firms being either in the US or in the UK. So yeah, I think cross jurisdictional learning, it's very, very important. Even if your plan is to just be in your own country to do your profession, you will always end up with an English written contract from an American. You will most probably end up with something like that in your profession in the future. So yeah, it's very important to study different jurisdictions.
Yeah, I mean, I feel like we are living in such a globalized world that every single day, whatever we buy is coming from a different place. And most of the companies that are very popular in Europe and in general in the world come from the US. So I feel like it's also important to understand their culture as well and to understand the way they are working. And in this sense, I'm wondering about the cultural perspective of mediation and of the mediations that you have involved with. How are these cultural differences between parties impacting the mediation process itself?
Yeah, so cultural dimensions are something you should always be aware of, and in my experience, they play an incredible role. So I have a few examples, but like how we communicate, the way the words we use, the way we approach our body language when dealing with multicultural mediation and disputes, it's for a mediator, it's extremely important to have at least an idea of the background, cultural background of the parties before they enter into, to help the parties make peace. Be aware of it, and because you will never know at the end during the mediation what's going to happen. It's very hard to predict, but at least be aware of there is someone from China that if you smile might interpret that smile as like I've done something wrong, or it might be someone that is very much influenced by an individual, like Europeans that say are seen as more individualistic, so the fact that they can take decisions by themselves. And then you have other cultures, like Italy and Southern Europe is a bit more like that, but like if you go to China, the Middle East is more like socially influenced. So a question that you might want to ask before you enter into the process of mediation is there anyone else that I should be considering, or you are the one taking decisions? So what happens sometimes is like, oh yeah, I have someone on the phone ready to be called because I want to advise, I get an advice before, I sign an agreement or before I say something. So always making sure that the parties are representing themselves, or if there's anyone else that has influence on them, that it's, it's reachable during the mediation process. So there's a lot of places where you can study cultures and cultural dynamics. I can't recall the name, but if you type cultural dimensions, there's a lot of studies being done there. So how to handle somehow differences or understand them. This is a big part of an international mediator for sure. Yeah, the study of cultural differences in China was the most fascinating thing I've experienced when I was sitting with the partner I was working with, and he was Chinese. He was explaining me the old dynamics in the conversation. I was like, whoa, he was telling me don't smile or smile when I smile, like this kind of stuff, which in Europe we never think about or take, It's a completely different, it's like a language, the body language, so you need to somehow learn that the same way that you learn a verbal language, written language.
Yeah, it is very insightful to hear all your information and all your experience. It seems that you have worked a lot in ADR, and especially in relationship to mediation.
Yeah.
So it seems that you have a lot of experience in ADR, and my question is referring to you as a mediator? Because you mentioned about the solution bias, you also mentioned the knowledge on the cultural differences of the parties. So I feel that the mediator has to be aware of different aspects of the mediation and of the parties as well. What are some other key elements that make a good mediator?
Yeah, so there is the like I said, working and understanding your own biases as a mediator is very important, being aware of it. I made the example of the solution bias, but it can also be solution-driven bias or bias towards certain preferences. It's not that you cannot have an opinion, but when you're in the mediation process, you sort of have to be yourself and neutral at the same time. So not projecting your own things onto the parties, which is hard because you might not like a violent communication and someone is being violent. So you might naturally go with the one that is more welcoming. Okay. So understanding those dynamics, I'd like the transactional analysis as a simple way to understanding some dynamics that can. So transactional analysis comes from psychology, and it looks at like 3 different roles that people usually take on when in disputes, for instance. So it's the adult, child, and parent, and it explains like in the communication you can see if someone like a boss, for instance, is playing the parent, and if he's playing the controlling parent or the more nurturing parent, and on the other side you have the child. So there's a lot of like background, some clues that you can get if you really study human behavior as a mediator. There are some clues that really can help you then understand and put, for instance, the parties more into the adult levels of things, so to be more rational, to understand like, okay, he might be triggered by certain words or certain things because he doesn't like dominance on them, therefore try to get the other party to be less dominant and see from the perspective of the other. So a lot of study from mediator, I think a lot of studying in how human behavior works, how communication works. And I would say even being creative sometimes in mediation. So for instance, if you feel like there's before the process starts, a few days before, if you feel like I really want to get to know the parties, this dispute is way too complex, way too obscure to me, you can even have a conversation with the parties, with both of them, of course, before the mediation, just to get to know them and for them to get to know you. Or if you have a feeling of they don't have trust in the mediation process, to just have a short conversation whereby you learn from them and they learn about you, so they will feel more comfortable during the procedure. That can be another idea. And like I said, being creative even during the process, like, I mean, getting the parties to walk around and like all these sorts of stuff are things that like really, you know, like, or to take pauses when it's the right time to do it, or to do a breath exercise, you know, like when they're heightened up. Otherwise they cannot. I mean, there are studies that say like if someone goes all the way into the limbic system and emotion starts to come up or whatever, they cannot think rationally for a certain amount of minutes. Like, I mean, it can be 18 minutes, 20 minutes, 25 minutes. They cannot really have a rational conversation because they're all hyped up, they're all emotional or whatever. So you might want to facilitate that process of getting them back to like, okay, rational logic thinking, we're trying to resolve a dispute here. These are all things that if you're not aware of it and you're not looking into, you might be missing, which are like essential to get the parties to really agree on something that they can recall and they can feel attached to, you know, rather than being just an emotional reaction. Yeah.
I feel that mediation is very unique in the sense that it actually takes into consideration that respect that the people are different and the cultural differences of the people that are taking part in the process. And I feel like this is very important, especially when it comes to commercial relationships, because it's actually making sure that the parties can stay at the same table and make contracts afterwards as well. Whereas, I don't know if it's just my impression, but courts and litigation tend to get pretty messy, and the parties will generally just terminate all the relationships. And I feel like mediation on the other side is way friendlier than litigation.
Yeah, I like to use metaphors. So like it's basically, I mean, with litigation, and arbitration is the same as court litigation, like in a way. It's basically, if you see two people that are mad at each other, it's like giving them knives. You know, this is litigation. Like you're just giving them knives to just fight. With mediation, is you go in between, hug them or whatever, or like you just go in between the thing and try to make peace and make sure that they both understand why this happened. And this is why, you know, when we discussed before this conversation, and I said like should be a default, is because we tend to think like there's someone else in a contractual relationship, because this is my, let's say, domain. We tend to think like, I don't trust this person, therefore if something happens, I know already I'm going to go to court. This is the assumption. Like there's only a court, you know, defending me. There's not like, instead of coming from a place of there is a relationship I need to take care of, and it's not just about me controlling everything, but it's more about just trusting. So creating trust in the relationship, it's very important from the beginning. And this is why in my work, a lot of times, you know, someone comes to me, and most of what I do is just contract drafting, or a negotiation. But then, you know, client comes and asks me, can you make this contract? And I always ask the question, who is the other party? And then it's like, oh yeah, it's this guy, whatever. And then the negotiation process starts, and there's all this like, oh no, but put that clause for us. Then make it stronger for this side, and make it stronger from like just, it's already before they started to do business, there is this tension created, whereby I am pushing my client's interest, and on the other side there's another legal person pushing for the interest of the other one, instead of, and this is the shift that I'm currently trying to do, is like, why don't, instead of having two legal parties defending two different interests, why there is not just one representing the relationship itself instead of representing one or the other, which is, in a dispute, is the mediator's role. But in before even the dispute arises, it's, I think the role of law is to make relationships work in a way, and always seeing it as a rivalrous dynamic in the contractual relationship. It's not very good. So this is my interest now, and I'm trying to see if there is interest from the parties as well, because a lot of times startups that want to get into a contractual relationship, they don't have the fundings to pay each of them their own lawyers, so they just hire me to do the whole thing. So I found myself in this position, being the one representing both, which is the best position you can find yourself in, because then you're
practically mediating a contract negotiation.
Yes. Which is, I mean, to me, it just sounds so obvious, right?
Yeah.
Why should it be that from the beginning there are two parties kind of, and the assumption of, even if it's only one lawyer involved, making it usually for the stronger party or the one who has more money to pay for it, or, I mean, it depends. There's a lot of reasons why they only have one. Usually it's considered to be the one, the one putting their own clauses, and the other one has to agree. Like, yeah, I think that's the mindset change when it comes to contract drafting that I would like to see, and the new role that a lawyer or legal professional can really play is, it's about representing the relationship. This is the easiest way that I can explain it. So not representing one party or the other, but really being the steward almost as of the relationship. And even if it's really neutral, the role that it played with the parties during the drafting of the agreement, if it kept being neutral, then it can even become the mediator if a dispute happens, because he was the one that created the agreement. He was the one that was witnessing the parties coming together and negotiation. So it might be also the best partner for a dispute resolution, which is again something that you don't see very often in the mediation field. Usually someone that has never seen the parties, which can be a good thing, but not always. So it happened with me, for instance, that I was called in on disputes that arose on contracts I drafted, and I played, I would say, the informal mediator role, whereby I put both parties in the call and I made them agree. And most of the time is about like changing the terms of an agreement because some external factors changed that made the agreement obsolete or not functioning properly for the parties. So it was just a matter of wording and a little bit of working some trust issues and ownership issues. Usually that's the main thing that happens in the startup field.
You know, regarding with the contracts, this is not really linked to mediation, but I feel like it's really interesting, the idea of smart contracts, as the legal contracts tend to be very, let's say, confusing sometimes and have different meanings. That's why arbitration courts and also litigation courts have to interpret the terms. So I'm wondering, how would smart contracts actually facilitate and the performance of contracts, and how does it work? I mean, would the idea of smart contracts actually have an impact on the caseload of litigators?
Smart contracts, you mean with the definition of like blockchain smart contracts? Or?
Yes.
Okay, cool. Okay, so if the listeners are familiar with that, I'll just go with it. So I did quite a lot of research into this. My opinion is, it depends. Like smart contracts are not smart. First of all, like it's about the automated enforcement of certain clauses. So that can work. I did a presentation on this topic actually a year and a half or something ago. So a smart contract can definitely, to some extent, help for some disputes are not arising, but if there is tension, usually it's not about the automated enforcement of an agreement. So like, payments happening seamlessly without the parties complaining about it. It can be like if there is manual payment and just a party continuously postpones, forgets, and all that can happen, that a dispute arises. But to me, it's not going to have a huge impact, I think, on disputes, the smart contract thing. What technology, although can happen in general to mitigate the arising of disputes, because it brings somehow trust out, like a lot of trust issues outside of the contract. So transparency of information, for instance, allowed by a transparent database that both parties have access to, which is confidential, that only the parties can see, or like I said, automated enforcement of certain things like payments, shipment, this sorts of stuff technology can be used for that. But smart contracts are, I wouldn't say that they would solve so many of the dispute issues in a contract.
Regarding the technological advances that you've mentioned, and with now that with the rise of the COVID pandemic, technology is making a very important role in the resolution of conflicts. And there have been various studies on whether it is sustainable and effective, whether it's working properly, whether it's going to be actually the rule for the future. And what is your opinion on this? Will actually online mediation?
Well, let's say online mediation serves its purpose if it's like the only way to do it, or I mean, if it's the inexpensive way to solve issues between parties that cannot, afford to fly from China to Amsterdam to resolve a dispute in 2 days. So it is the future. I never really experienced like awkward situation online, to be honest. I mean, you as a mediator have to be just very good at facilitating the whole online process. Like you could imagine the parties already hyped up. They probably don't really want to be there. They would just do rather something else. So to be very good at facilitating the whole online experience can be good. So like getting them to do homeworks while they wait because you're working with you're talking to the other party, like, and getting them to get engaged instead of losing attention in what they're doing. It's very important. And in the physical mediation, it's much easier to do that. And in digital space, it's not. So really, I think it's about educating the mediator. And I think the parties are kind of getting educated now, the more, I mean, we're behind the screen. Although, so yes, it's the future, but I am not a big fan of moving everything to online. Although, I mean, I work with tech and I love technology, but the more we can meet each other physically, the better, post-COVID, of course.
Yeah. And now, as a last question, because you do have a background in law and you had various internships and work opportunities outside of Europe, but I'm wondering, in terms of technology, did you have any formal education, or did you have any particular courses that you take?
Yeah, I did take some courses when I started to work in blockchain, but it really depends on. So, absolutely, I would recommend students to go if they are interested in just learning technology to see what's around this million online courses for very affordable prices. My way of learning, just because this is how I learn by communicating mostly with people. So what I did in the past, when I was also finding it so hard to learn about blockchain, when I didn't even know how the internet properly worked, was so hard. So then I remember I had a deal with one of the clients. I said, like, okay, I offer you free advice on this and this and this matter, but you promise me a few hours of deep diving blockchain. And this is how I learned mostly. So I learned with clients really. So, which is the beauty of just working by yourself, is that you can be honest to your client and say, like, hey, I really don't know how it works, and you don't know how the law works. So this is mutual. That's it. Let's make it work. And this was, I think, the biggest learning in blockchain was from that. And when then we started discussing open source topics, which were obscure to the developers and software engineers, then I could see that with open source was where basically everything kind of meshed together, law and tech. So we could have very good discussion where it was like mutual learning happening. It was very cool. So that's how I did it. But you can do it in many ways. There's like, the Udemy kind of thing offers quite some good courses to just have an idea of whatever technology you want to learn about, how it works. Yeah.
Thank you very much. I think this is the moment to wrap it off. I would like to thank you very much for your interest once again and for having taken part in the podcast. I hope you have enjoyed it.
Yeah, a lot. And I mean, if your listeners find it useful or want to get in touch, feel free to do so. I'm always very excited to talk to students, because although it's been now 7 years, 6 years since I graduated, I still feel like engaging with students and influencing them in their decisions and maybe inspiring them to be courageous in their choices of their future career.
Yeah, the session today, I feel like for me personally, which I'm very interested in mediation, it was a very inspiring session. It was definitely helpful to understand what a mediator actually does and what are some skills apart from knowledge. What are some skills that are paramount in becoming a mediator?
Thank you, Andra.
You've reached the end of this episode. If you have enjoyed it, follow us on Spotify, subscribe to our YouTube channel, and check out our weekly blog posts on our website. Thank you for listening.